Good morning and welcome. My name is Malcolm Neekirk. Today's coffee break briefing is on the subject of creditors' committees. So these are the points I'd like to be talking about this morning. Why do we have creditors' committees? Obviously they are there to set remuneration, but what are the other issues that we need committees to deal with? I'll be talking about how we set up committees, timing issues around setting them up, procedural issues to follow, and how to go about actually electing members to the committee if you should have the luxury of a contested election for that. And finally, I'll be talking about working with the committee, factors to think about there, how to get a balanced committee, and how to deal with conflicts of interest. So first of these things is, what are they for? Remuneration. And of course, this is the main thing that we think about as being the purpose for having a committee. I'm not going to talk about this in any great detail. The basics, I'm sure, are well understood, which is that when you've got a committee, the committee sets the basis for your remuneration. And if the committee is either not in being, or if it fails to set the basis for your remuneration, you then move on, usually to the creditors, and then beyond that, either to the court or onto scale rates, depending upon what the procedure is. And I'm not going to say anything about this slide, which is about the basis for remuneration, but it will be there in the handouts if you'd like to refer to it later. So what are the other issues that creditors committees may be there for? And as you see, there is an ANARAC warning for this particular slide. Deeply technical stuff here, the sort of stuff that you are not likely to come across very frequently. So if ever you need to restore the director's powers in a creditor's voluntary liquidation, you'll need sanction for the committee to do that. It is possible to do a Section 110 reconstruction in a creditor's voluntary liquidation. We're much more used to them in members' voluntary liquidations, of course. But if you are doing a Section 110 CVL, then the sanction that you need for the CVL should come from the committee rather than the shareholders. If you're a liquidator making calls on shareholders in a CVL, you need sanction from the committee for that. One that's not quite so ANARAC-y is in a CVL, if you are selling assets to a connected party, then you need to give notice of that disposal to the committee. And that also applies to compulsory liquidation and bankruptcies as well. And in those procedures, you also need to advise the committee if you are going to appoint a solicitor. There's more. In a bankruptcy, it is possible to distribute assets in specie to creditors. I don't think I've ever seen a bankruptcy where that's been done. It's not particularly common. You need the approval of the committee for that. A relatively new one, this is where you have an arbitration clause in a contract that came into existence before the bankruptcy order was made. You haven't adopted the contract, and now you want to use the arbitration clause. You need to go to the committee for that. Administration orders, the administrator has resigned. You need to get a new administrator appointed by court order to replace the resigning administrator. It should be the committee who make the application to court for that. There are other interested parties who can step in if the committee don't do that, but essentially the committee has first dibs on applying for the appointment of a new administrator. In most administrations, when you need your release, that is for the committee to grant when you vacate office. And in bankruptcies, when you are selling assets on deferred payment terms, you need to involve the committee in that, in agreeing the terms that you are going to agree with the purchaser. Then we come on to the more common uses of a committee, which is incredibly loose and incredibly vague. There are two general statutory functions that all committees have got, either to assist the office holder, or the second one is to do whatever may be agreed with the office holder. And of course, in voluntary arrangements, there is no statutory committee. The R3 standard conditions for IVAs suggest that the supervisor has the power to consult a committee and either ask for their advice or ask for them to make a decision. And the supervisor has the option of then following the advice or decision that the committee has made, but is not obliged to do so. And most voluntary arrangements tend to contain a committee powers clause that is similar to that. So what that means is, really, I think there are four main uses for a committee, other than the statutory function of setting your remuneration. And these really are, well, the first three of them are much the same as the three purposes for holding any meeting in business. Meetings can be either decisive, which in this particular case would be where you're effectively treating the committee as being your client, and you are putting decisions to them and asking them to decide what direction the particular insolvency should take on a particular point of difficulty. Second reason for holding a meeting is for it to be consultative, where you are going to be telling people what's going on, and you are going to be asking for their opinions, their expertise, their knowledge, as a way of informing your decision-making process and helping you to make a better decision. Effectively, to use the committee as a sounding board. And that's the second purpose for using the committee, is to tell them what you are thinking about doing, hear their opinions, and then decide what you're going to do in the light of what they want, but without actually giving them the decision about which direction you're going to take. And the third reason for having a meeting is to have an informative meeting. This is where you gather people together into one room and you tell them what's going on. If you do it well, they might think it's a consultative meeting, and they might think that you are going to change your mind, or you might change your mind on the basis of any opinions or facts that they present to you. But if it is an informative meeting, you will already have decided what you're going to do, and you may politely listen to what they've got to say, but it's actually not going to change your mind. So that's the third purpose for having the committee there, is because they are a bridge between you and the body of creditors. And if you want to get information to at least the most interested creditors, then talking to the committee is a useful way of doing it. I've got a fourth one on there, which is not a normal function of meetings in business. Well, maybe it is, but it's the CYA discussion. It's where there's some regulatory issue that's coming up, and actually to have consulted significant creditors, to have listened to what they've got to say, and to have taken their views into account is going to be a useful thing to do. And that sort of regulatory function, that can be done through a committee acting as either a decisive body, a consultative body, or an informative body. But it's helpful to sometimes have a note on the file to show that you have actually put the proposed course of action in front of the interested creditors, and you've listened to their thoughts about which way it's going to go. So that's the first part of what I want to talk about, what we have committees for. I'm now going to move on to talk about the issues around setting them up, and in particular timing issues. I mean, this slide really is for me to discuss whether you would find it useful to have a committee or not, whether you want to try and encourage the creditors to form a committee. So first question you might be thinking about there is, what is the best way of getting your remuneration fixed? Is it going to be easier done through a committee, or is it going to be better put to the general body of creditors? And that might also involve you thinking about when you want to get your remuneration set. You may need to refer back to some of these anarchy points, these technical issues where you might actually need to get a decision from the committee on a particular topic, in which case it will be easier to have a committee. There may be specific issues around the case that you're dealing with, where having a committee to consult, effectively having a client that you can ask for instructions, and where you can actually give them advice on which way you think the case should go for them to give you instructions, could be really useful. And I'm thinking there that one example might be cases where there are high stakes litigation, and it's going to be helpful to have the committee think about whether they would rather you paid them a dividend within the next 6 months or so, or whether they're happy for you to hang on to the funds in the estate to try and get a better recovery sometime next year. And the other thing to think about as well is how representative the committee will be. And in this sense, if you've actually got a committee who between them represent a majority of the creditors by value, then you can be reasonably sure that if you've got the committee on side, if you need a formal resolution to be passed by the creditors, then the fact that the committee are in agreement means that you ought to get that resolution through. The second thing that's important about the timing issues, technical point here, is that under the insolvency rules, the committee is not established. Effectively, it does not come into being until after you have sent the notice of its membership to Companies House, the court, or the official receiver, as the case may be. And until you've done that, the committee cannot make a decision. So that means that you could have a committee that is set up at a first virtual meeting of creditors, and yet because you have not sent notice of membership through to Companies House, the committee doesn't actually have the power to set your remuneration. That power is still with the body of creditors. Now, that might be convenient or it may be inconvenient. If it's convenient, you then get your fee resolution in front of the creditors and get them to vote on it. If it's inconvenient, you might want to hold an informal meeting of the committee and discuss the issue around your remuneration until you've got agreement with the committee. You'll then perhaps get a short minute circulated just to say that that was agreed informally, with the note being that there will then be, you'll then ask them to pass a formal resolution along those lines just as soon as they are formally established. And that will be a way of then transferring the decision across, and you hope they won't have changed their minds a couple of days later when you have actually then sent the notice of membership to establish the committee. There are some procedural issues around setting up a committee. The first one is exactly how you word the resolution to establish a committee, and I am really quite impressed with the drafting of the rules on this, which is that the decision you should be seeking is to invite the creditors to decide whether a committee should be established if sufficient creditors are willing to be members. And that means that even if they pass that resolution, there is still no committee unless and until you've got at least 3 creditors willing to be members. Second point I want to make here is that, of course, the rules say that when you send that resolution around, you should also ask for nominations for membership. There's no prescribed form for doing that. There's no stipulations as to what that says. But one thing that I have seen is that sometimes the invitation to form a committee is quite informally worded. And I don't think that's right, because what the statutory requirements are is that whenever you are asking creditors to make a decision about anything, you have to do that by either deemed consent in those cases where you can use deemed consent, or you have to follow a decision procedure. And there are no options for getting a creditor by any other means other than by deemed consent or by following a decision procedure. So I think that very often what is going to be easiest is to actually put that resolution to creditors by deemed consent, on the basis that it'll go through on the nod, but it will take effect only if at least 3 creditors put themselves forward. And I've actually got a specimen deemed consent notice for this that I will be circulating with the notes on this. So the wording that I suggest is on this slide. I'll be circulating that afterwards, and very similar wording on the model deemed consent notice that I'll be sending through later. Again, small anorak warning for this particular slide, but just remember that in court cases, bankruptcies and compulsory liquidations, the Secretary of State has the functions and powers of the committee in cases where there is not one appointed. Okay, in terms of setting up committees, let's move on to how we elect members. Now, as you know, you need 3, 4, or 5 members for a committee, not less than 3, not more than 5. The anorak point here is that in liquidations, you can actually have bigger committees. If it is a compulsory liquidation and it's solvent, that's a rarity, isn't it? But if it's one of those, then in addition to the committee members appointed by the creditors, you can also have members appointed by the contributories, the shareholders, and they can appoint, they don't have to appoint any, but they can appoint up to 3. So you can have 8 on the committee in a solvent compulsory liquidation, and in a creditor's voluntary liquidation, the members have got the right to appoint up to 5 more members to the committee. So in a CVL, you could have up to 10 members. Now, normally, if the members appoint members to the committee, the creditors would probably chuck them off right away, which they've got the right to do. And I think the only cases where you might actually think it's appropriate to have shareholder representatives on the liquidation committee in a CVL is where you've got a CVL which is likely to end up being solvent. Can sometimes happen, but that's perhaps something to talk about on another day. So you would need an election if there are more than 5 creditors validly nominated to the committee. And the other occasion when you might need an election, and this might happen more frequently in a bankruptcy, I suspect, is where you've got enough but not too many nominated to the committee, and it's actually really contentious, really heaty. And in a case like that, you might actually want to have the election conducted at a virtual meeting. So how do you run a contested election? I've got three suggestions here. There are other ways of doing it. So the first of these would be, this is probably best done at a virtual meeting because it involves a bit of dialogue between you and the creditors. Take the nominations presented by the 5 largest creditors, or whatever means you think is a fair way of selecting a balanced committee. Put a resolution to the virtual meeting that those 5 be appointed to the committee, and ask for that to be passed on a show of hands, effectively saying, can we just treat that as being passed? If there are no objections, would anybody like to object? And if there are objections, you should then put it to a vote, and the resolution that you ask them to vote on could simply be, as you have suggested, that the named 5 largest creditors be appointed to the committee. Second suggestion as to how to do this would be, this could be done by remote voting or at a virtual meeting, and this would be to follow the contested trustee procedure for bankruptcies set by the insolvency rules, and this involves successive rounds of voting, and at the end of each round of voting, the last placed candidate drops out. Now, the great thing about this, which may be useful, is this can go on for a very, very long time, because you may have to circulate a formal resolution with a formal closing date for each round of voting, and it could take weeks before you've actually got the committee appointed. That may be convenient. You could also have a similar procedure by using a single transferable vote, where each creditor is asked to list their 5 preferred choices of members for the committee in order of preference. But you would have to plan that carefully and set the rules out very carefully, because there are many different systems and procedures for a single transferable vote. Third suggestion is that you simply pick 5 and you send a deemed consent notice around to say that these 5 are going to be appointed to the committee. If creditors don't like it, as always with deemed consent, they can block your choice, and you'll then have to put it to a decision procedure. If you're going to be doing that, then it would make sense to ensure that you circulate a note to explain why you have chosen those particular 5 for the committee, so that creditors can see your reasoning, and so can regulators as well. Final point on actually electing members of the committee is, again, slightly anarchy one. Just remember, please, that it is the creditor who is the member of the committee, not the representative of that creditor. And do please make sure that your nomination forms make that clear. I've sometimes seen forms that are a little bit ambiguous in that regard, and that can cause confusion. Okay, I'm now going to talk about working with the committee, and the first point there is talking about balancing the committee. And what I mean by balancing the committee is trying to get a committee, if you're going to be working with this committee and they are going to be useful, try and make sure that they are representative of the creditors as a whole so far as possible. So you would be trying to get members who are drawn across the range of different creditors who have an interest in the insolvency, and ideally you would also be looking to get creditors who actually represent a significant part of the total. It's great if you can get above 50%, but if they are genuinely a large proportion of the total debts owed by the company or the bankrupt, then you have got a committee who are able to speak for the creditors. And I say particularly if they represent a variety of different interest groups as well. Final points I want to talk about here are conflicts of interest. The Insolvency rules deal with dealings between the office holder and a committee member, which is broadly speaking something that you can do. You can sell stuff to members of the committee, but you have to make sure the transaction is for full value, and you have to disclose the proposed sale to the committee and get them to agree it. Obviously, the party who is buying the stuff can't vote when it goes to a vote at the committee. Second area where you do see conflicts of interest arising is if you've got potential claims against a committee member. Could be a liquidation. The directors could be significant creditors in their own right, and you may have significant claims that you want to bring against the directors. That's not regulated by the insolvency rules, but I think as a matter of good practice, good corporate governance, you would have to exclude the member from the discussions about the relevant part of the meeting, and certainly from voting about whether to bring a claim against them. That's the sort of area where you might find it useful to set up an informal committee. I will say a few words about informal committees right at the end. The other case where you might have conflicts of interest, quite likely to arise in some bankruptcies, where you might have members of the family who are creditors of the bankrupt as well, and they may be sufficiently significant to get themselves appointed onto the committee. Again, that's not regulated by the insolvency rules, but you would have to assume that the bankrupt's son, or whoever it is on the committee, is actually reporting back to the bankrupt with all of the details of everything that's going on at the discussions that they're participating in. Nothing you can do about that, except possibly exclude that particular member from the relevant part of the meeting. Don't allow them to vote. And again, this is a case where possibly setting up an informal committee might be quite useful. So I'll say a few words about informal committees. They can be incredibly useful. They are like a committee, but where they're expressly agreed not to be a statutory committee, and where they are therefore not regulated by the insolvency rules. You may well have a formal committee running in parallel as well. Because it's not a statutory committee, you may have fewer than three members. You may have more than 5 members. They are, of course, unable to take statutory decisions, but it is going to be important to make sure that they are in some way representative of the creditors. This may be because they are the majority of unconnected creditors, or it may be because they are funding or otherwise assisting the office holder. And I always think that transparency in insolvency is usually a good idea. So it would make sense for you to disclose the existence and possibly the composition of the informal committee, and perhaps also, to the extent that you can, disclosing the minutes of its meetings. They may have to be heavily redacted. By the time you've redacted them, there may actually be not much there. Right, that brings me to the end of the topics I wanted to talk about. My apologies, I have gone a few minutes over. I am sorry about that. If you've got any questions, please do ask them now. I've got a couple of points here. I think I may have to pick up both of those later because I'm going to have to look at the rules to deal with them. So my apologies, but I will circulate the questions and my thoughts on them when I send the notes out for this. So if there are no further questions, I will say thank you all very much for participating. have a really good break over Christmas, and I look forward to seeing you all again in the new year. So thank you all, and goodbye.